I call this meeting to order. Welcome to meeting number 37 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order of reference of October 31st, the committee is meeting to begin its study of Bill C-9, an act to amend the Judges Act. Today's meeting is taking place in hybrid format pursuant to House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating via video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. We appreciate your patience. I also use elementary cue cards just to tell you when there's 30 seconds remaining and when you're out of time, so I don't like interrupting. So hopefully keep your eye out for that. This committee is actually really good on keeping time. I'd now like to welcome our first witness appearing today. We have the good pleasure.
Monsieur le Président, avant qu'on débute,
Before we begin, I just have a quick point of order. Can you please confirm whether sound tests were conducted for each of the witnesses? Even though I believe no one is appearing virtually, but I want to make sure that the sound tests were done.
They were done, Monsieur, and even the panelists, the members online have been tested as well. Thank you. So again, I'd like to welcome the Honourable David Lametti, Minister of Justice and Attorney General. Thank you for returning to this committee, and the floor is yours for 5 minutes.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair, and it's always an honour and a pleasure to be with you here today, with you in person for the most part, and I'm happy to see Mr. Garrison and Mr. MacDonald on the screen. I'm accompanied here today by my colleagues from the Department of Justice, Nancy Ottmer, Patrick Xavier, and Anna Decker, and they will be assisting me if ever there are technical questions. Thank you.
It's an honor for me to be here today to speak to you about Bill C-9, which is an act to amend the Judges Act. I take this opportunity to thank you all for the unanimous support of this bill at second reading. As you know, this bill reforms the process used to address complaints against federally appointed judges. The soundness and effectiveness of the judicial conduct review process can have a significant impact on the independence of the judiciary. This legislation will make the judicial conduct review process more efficient and more cost-effective. This legislation is the fruit of years of careful study and analysis, including consultations between the legal community and the general public, and extensive dialogue with the Canadian Judicial Council and the Canadian Superior Court's Judges Association. In my view, Bill C-9 sets out what would become a world-leading judicial conduct review process, and one that will serve Canadians exceptionally well for years to come.
We need a judiciary that is strongly independent, one that is able to render judgments without fear of reprisal. At the same time, Canadians rightly demand to hold judges accountable to a high standard of professionalism. In 1971, Parliament, through the Judges Act, assigned responsibility for handling complaints against judges to the Canadian Judicial Council, or the CJC. The Judges Act sets out the key elements of a process that served Canadians well for decades. However, shortcomings in the legislative framework have become more and more pronounced over the last few years, prompting growing calls for Parliament to act. This includes calls from the CJC itself.
In developing reforms, the government carefully considered feedback from the general public received through an online survey, as well as from a number of key stakeholders, including the Canadian Bar Association, the Federation of Law Societies, and provinces and territories. We listened carefully. Our focus was to craft a process that the public would have confidence in, one that is rigorous and fair, yet timely and effective. Constitutional principles dictate that a judge cannot be removed from office without having a judge-led hearing into their conduct. As I noted, Parliament has assigned this important task to the CJC. In light of this, my department's officials engaged in sustained discussions with the CJC to ensure this legislative proposal could benefit from the Council's 50-year experience running the judicial conduct review process. Departmental officials also engaged with the Canadian Superior Court Judges Association to understand its concerns regarding process reform. I take this opportunity to thank both the CJC and the Association for these discussions and for their commitment to serving Canadians. Je souhaite maintenir sur les
I wish here to highlight two main areas of particular concern. One is efficiency. As it stands, the process takes too long and is too expensive. Of course, the Constitution demands rigor and sensitivity in the handling of complaints against judges. Yet, when the resolution of complaints at times stretches on for years on end and at great expense, Canadians rightly ask whether there is a better way. This is perhaps best underscored by the multiplication of judicial reviews that we have witnessed over the last few years with respect to certain complaints, creating the perception that judges launch these proceedings to effect delay rather than to pursue legitimate legal interests. Bill C-9 responds directly to these concerns by making the process much more efficient.
A second shortcoming involves the all-or-nothing nature of the existing process, which is designed to answer a single question. Does the complaint warrant the judge's removal from office? No other sanction is available. This fact colors every step in the process. This risks unfairness to judges subject to complaints who may be subject to a full-scale inquiry and its proceedings for conduct that would more appropriately be addressed through lesser sanctions. Further, this risks undermining the public's trust in the process. Members of the public may be perplexed and rightly dissatisfied when complaints are dismissed, despite problematic conduct, because the conduct in question did not reach the high threshold of justifying removal from office. Bill C-9 addresses this concern by introducing, for the first time, the ability to impose sanctions for misconduct that do not warrant removal from office, but that nonetheless demand some form of remedy and accountability. These could include, for example, mandating training sessions. I have not time in these remarks to discuss all of the improvements proposed by the bill. In the time I have left, let me highlight three key improvements. Premièrement,
first, greater transparency through greater participation of lay members. The current process has a limited role for lay members, which in this context refers to individuals who are not judges or lawyers. There is currently one lay member on the 5-member review panels. Bill C-9 changes this. There would continue to be one lay member on review panels, but these review panels would be more efficient, having only 3 members and being empowered to impose sanctions for any misconduct not serious enough to warrant removal from office. Second, hearing panels established to conduct public hearings on whether a judge should be removed from office would now include a lay member. These improvements directly address the system's current shortcomings, increasing efficiency and allowing for more appropriate and targeted accountability.
the second point to highlight is how Bill C-9 streamlines the appeal process. The current process provides too many opportunities for judges subject to complaints to seek judicial review of decisions made by the Council at different stages in the process. This is costly, results in excessive delay, and undermines public confidence. Further, after the Inquiry Committee has issued its recommendation on whether a judge should be removed from office, the current process requires review of this decision by what is termed Council of the Whole, where quorum requires participation by at least 17 CJC members. This body's powers are unclear, and legal decision-making by a body of this size has proven challenging. To address both of these concerns, Bill C-9 would introduce an appeal mechanism internal to the judicial conduct process. An appeal panel made up of 3 CJC members and 2 puisne judges would have broad powers to remedy any shortcomings in the process, and the only recourse available to the judge wishing to challenge the decision of an appeal panel would be to seek leave to appeal directly to the Supreme Court of Canada. Entrusting process oversight to the Supreme Court will reinforce public confidence and avoid lengthy judicial review proceedings through several levels of court. This will save time and costs while still providing robust fairness for judges subject to complaints. Le troisième et dernier.
The third and final point to highlight relates to the costs associated with the process. The day-to-day costs of handling complaints are fairly consistent and predictable, and would continue to be so under the new process. However, the costs associated with inquiry committees are highly variable and unpredictable given the significant year-to-year variability in the number of public inquiries conducted. And as a result, administrators must rely on complex mechanisms to seek necessary funding on an ad hoc basis. This is a long-standing problem that Bill C-9 would rectify by introducing a statutory appropriation to provide a stable funding mechanism for the highly variable portion of the process's costs associated with public hearings. This is not only a sound practical solution, but it is also justified by the fact that these public hearings are constitutionally required. To ensure sound stewardship of these funds, the bill would introduce several measures, including requiring that an independent review be completed every 5 years into all costs paid through the statutory appropriation. The findings and recommendations of this review would be made public.
Thank you for your time and attention today. I wholeheartedly recommend this bill, knowing that it will profoundly improve the judicial conduct review process to the benefit of Canadians. I look forward to your questions after having had a glass of water. Thank you.
And now we'll go to the first round to Mr. Brock for 6 minutes.
Thank you, Mr. Chair, and welcome back, Minister. It's always a pleasure to have you here and sharing your expertise with respect to our studies, and you are indeed correct. We will continue to support C9 going forward. That is a given. Given my background, it's just very, very important that we all hold ourselves responsible for the conduct of our actions, and judges are no different. So I'd like to start off by asking you this question. I think you'd agree with me that, in your opinion, Bill C-9 strikes the appropriate balance between maintaining the confidence of the public with respect to our judiciary and those of the complainant's interests. You'd agree with that?
I definitely do agree with that. First of all, there's more transparency to the system for the complainant, for the person who files the initial complaint. There's a greater deal. There's a greater amount of lay participation in the system, as well as a balanced amount of expert participation in the system, lawyers and judges. And there's very much a streamlined process, so that for the complainant, they won't see all of these side appeals to the federal court on judicial review. So not technically appeals, but you know what I mean.
Thank you, Minister.
Okay.
I have a limited amount of time. I have a lot
Please.
to get through. You may or may not agree with me, but the public confidence in our judiciary has been shaken significantly as a result of some pretty controversial Supreme Court of Canada decisions. And with the time permitting, I want to touch upon 2 decisions, Bissonnette and Sharma, because in my view, you need to know what the feeling is on the street, in the community, and I want to have your thoughts in terms of the government response. So as we know, in the Bissonnette decision, the Supreme Court of Canada unanimously struck down 745.51 of the Criminal Code as violating Section 12 of the Charter, not saved by Section 1, and made it retroactive to the day it was enacted, in this case 2011. We all know the facts of the case. We need not belabor the point. It was a horrendous crime that shook the conscience not only of the Muslim community, but that across the country. In the ruling, the justices indicated that having a longer period of parole eligibility, in this case upwards to 75 years, were degrading in nature and incompatible with human dignity because they deny offenders any possibility of reintegration into society, which presupposes definitely and irreversibly that they lack the capacity to reform and re-enter society. Although Parliament has latitude to establish sentences whose severity expresses society's condemnation of the offense committed, it may not prescribe a sentence that deprives every offender a realistic possibility of parole. Minister, I want you to listen very carefully to the words we heard from various victims when we studied the government's response to victims of crime. One such victim was Charlene Bosma. She indicated on May the 6th, 2013, her husband Tim was taken from their home, shot in his own truck across the road from our house, his body eventually taken to the Waterloo airport and then burned in an animal incinerator. She spent 8 days searching the province for him, not knowing where he was. On the 8th day, her world fell apart when she learned one of the most horrifying phrases in the English language. His body was burned beyond recognition. She says, I can't convey the overwhelming amount of joy and relief that we as a family shared in the courts determining consecutive life sentences in each case, 75 years and 50 years for the co-accused for cold-blooded, heartless killing. As the mother of a little girl who was not quite 2.5 when her father was murdered, I was extremely thankful that she would never, ever have to face the monsters that killed her father for no reason other than they simply could. In May of this year, our government took away one of the very few things that we as victims had to hold on to, which was consecutive sentencing. And one of the greatest blows that the Canadian government has ever dealt to victims of violent crime. It says to us that you can kill as many people as you want here in Canada because sentencing will not change. It says that Canada only places values on the first victim with the lives of any other victims not mattering. Not here, not in Canada. We also heard from another family who indicated the profound impacts that this decision has had. I know that you have shown compassion in the House of Commons, Minister, when the decision was released. I'm looking at a news release from one of the publications on the internet, and in a media statement you had indicated as following. Our position was clear. We supported a sentencing judge's discretion to impose a longer period of parole ineligibility where appropriate. However, we will respect the court's decision and carefully review its implications and the path forward. Since hearing those words, and I remember you in the House using those words or similar words, what has the government done? What is the government doing to address the pain that these victims are feeling and the overall sense that this is no longer a justice system but merely a legal system?
Unfortunately, Mr. Lemaitre, you have 10 seconds to answer this, so I don't believe it also was relevant, Mr. Brock, to the bill, but I'll still give him the opportunity to answer.
It's unfortunate. I would like to answer the question. I'm open to ideas. We're studying that decision. We're trying to be compassionate to victims. Note that the court did not change the total sentence. The consecutive sentences still exist. The court did not strike that down. What they did do unequivocally was say that you needed to have a chance at parole at different stages in that process. They left the sentences, however, intact. It is, as you pointed out, a 9-0 decision. It's a clear decision by the Supreme Court. So it doesn't present an easy map forward, but I'm open. We are studying the decision. We're studying ways to support victims, but we're also looking at the decision, and I'm open to good ideas.
Thank you, Mr. Lemaitre, and thank you, Mr. Brock. Over to you, Madame Briard.
Merci beaucoup.
Thank you very much, Minister. It's always a pleasure to have you before this committee. As you know, the Giroir ruling was quite a saga. It was in the media. And you referred to this. How would Bill C-9 reduce delays and costs? And how would it make the process, the complaint process, more efficient? Thank you very much, Ms. Brière, for your question. In the Giroir case, what we saw, unfortunately, was that every time there was a possibility to use an appeal or a review, every time there was a possibility to use a new tactic, it was done in order to prolong the entire process. And what it did was increase the cost, it increased the period of time involved. And by the time the Supreme Court finally turned down the appeal, and by the way, I stated to Parliament that I was willing to revoke this judge. He ended up leaving with his entire pension. We had already dealt with pension issues in the fall, and we did this about a year and a half ago. But what we need to do now is correct the process. And this is a process that follows some very direct lines. There's a transparent process, and the panels are made up of lawyers, lay members, judges, and they're very clear lines to any sort of appeal process. So the process can be trusted, and the judge can trust that he or her will be treated fairly, as well as the public at large. The public at large will see a less costly, more efficient, and shorter and transparent process. Thank you very much. You also stated that there could be sanctions when the situation doesn't necessarily warrant removal of a judge. Could you expand on those new sanctions, please?
On a créé la possibilité.
Well, what we've done is create the possibility of imposing lesser sanctions, more flexible sanctions. Under the former system, there was only one sanction, and that was the removal of a judge. But there were cases where a judge might have made a mistake that, yes, was serious, but not serious enough necessarily to warrant removing a judge. Now we have under this process, we have a parallel process that can determine whether or not that judge is guilty of what happened, but the sanction will be better adapted to the situation. One of the examples I could give you, for example, would be some kind of training. For example, a judge might have made an inappropriate comment during a trial, for example, involving sexual assault. Now, the sanction might be to follow some training to redirect that judge, make that judge more sensitive, and to be able to, at the same time, retain a judge who has shown their abilities in other areas. And there could also be apologies. Yes, obviously, there could also be apologies. Now, can you explain why lay members would be useful to these panels and an advantage? And I didn't see whether or not, for example, a member of the Notaries Association could be one of those.
Je vous en tiendrai pas rigueur.
Don't
hold me to that.
Maître la notaire. Prière. Donc, c'est important.
What is important is to have lay members involved, not only to give that important perspective during a process, but because this person, this individual, will be able to represent the experiences and perspectives of people who don't have that legal expertise. So that experience itself is very important, and therefore their participation is very important. But what it also does is make the process transparent. We don't only have, in that case, judges and lawyers involved.
C'est terminé.
Is that all for my time? Yes.
Next, we'll go to Monsieur Fortin for.
Merci, Monsieur le Président.
Thank you, Chair. Minister, thank you for coming today. It's always a pleasure to have you here. I have several questions I'd love to be able to ask you on various topics, but I'm going to try and stay focused on today's topic, C9. And just so you know, I think it's a good bill. The Bloc will be supporting it. However, Minister, I do have some questions. For example, there are various complaints that are dealt by the CJC. And I'm wondering if we couldn't deal with these situations upstream through the selection criteria. I know that there have been improvements over the years, and we have spoken about these on our part, on the part of the Bloc Québécois. For example, we've talked about political screening before selections. So what I'm thinking is that perhaps we could improve these screening measures, not only providing academic and legal training, but also perhaps providing some kind of moral perspective or moral screening, looking at how these individuals behave when there is an issue like this. So do you not think the selection process could be improved in order to make sure that there are less and less complaints laid? Well, I agree with you. And I think we have done this in the changes we've made to the system, because what we really are doing is focusing on judgment, experience, professional training, and through that person's experience and engagement in society, through looking at their careers and looking at other qualities, that's exactly what we are trying to do. We're looking at the appropriate qualities, for example, wisdom, maturity. So we are looking for those qualities. And under C3, what we wanted to do was focus on the training of judges. So training is actually a prerequisite for people who are candidates. So that should also improve the quality of this decision-making. Thank you, Minister. But what I'm wondering is, what can we do actually concretely? Let's say there's a certain number of candidates. Because when you look at academic criteria, well, I think the selection committee can deal with that. Nobody is going to come forward as a candidate who won't necessarily be competent when it comes to their academic competency. However, concretely, how can you actually determine the moral values and the future behavior of a candidate when they are faced with these kinds of situations? Now, obviously, one has to respect the Charter and any other privacy issues. However, have you considered the possibility to be able to confirm somehow the moral values? Well, to the extent that it's possible, we do that. Yes, there are privacy laws, but we do have consultative committees, we have advisory committees, they ask questions, they do their research, and there are also conversations with other judges and other lawyers that take place. And these are judges and lawyers with a certain amount of experience. Now, we don't necessarily have a set list, but we do look at their general experience. And we look for people who are able to articulate their moral values. Thank you, Minister. Do I have much time left? I want to speak to another topic completely. There are some interesting sections in Bill C-9, and I'm wondering whether you have considered any kind of mediation process. So before this even becomes a legal topic or legal issue, before a complaint is laid, is there any mediation process that could help? Is there any way your own department could intervene and could, with the CJC, look at if there's a way to mediate the process or any kind of, or think of sanctions together that would avoid cases like the Giroir case? Well, after the initial review, there is a less formal committee or panel that allows for that kind of discussion. Perhaps I could give the floor to one of the people accompanying me, because it's the judiciary that actually was engaged with us in talking about Bill C-9 initially. Perhaps I could just ask you to repeat your question. I'm sorry, quite quickly, I have 30 seconds left. I'm wondering if there's any way to have a mediation process. For example, let's take the Superior Court, for example. And before being given a date, there's a question to the effect as to whether or not there was a mediation attempted. Now, in the case of Giroir, this was a lengthy process, and I'm wondering if a mediation process would have allowed an agreement to be reached with that judge to resolve the issue and to agree to sanctions. Well, it's difficult to say in the case of Judge Giroir. Giroir had been the subject of allegations at the time that I don't necessarily think an agreement could have been reached on through a mediation process. However, there is a review panel at the very beginning of the process. And
Thank you. Time's up.
I apologize.
Thank you, Monsieur Fortin. We'll next go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to the Minister for being available to the committee to talk about C-9 today. Obviously, there's a great deal of consensus that C-9 will fix some of the major problems in the complaints process, and I appreciate the Minister stressing that it would fix the kind of all-or-nothing problem and allow dealing effectively with lesser forms of judicial misconduct that might not involve removal from the bench. And of course, streamlining the timing is in the interest of everyone, and as is reducing costs. But I think there are two further questions that I have about C-9 and about the process in general. And those revolve around transparency and fairness of the proceedings. I think right now there's a general feeling that there isn't a great deal of transparency about the outcomes of complaints against those who have committed misconduct on the bench. And I wonder whether C-9 will make any improvements, or are there any other suggestions to improve the transparency of the outcomes of the process?
Thank you, Mr. Garrison, for that question. The process will result in more published decisions, and certainly anything that the minister has to do at the end of it will also be public. And I think that's a better process than exists right now. The proceedings themselves, to my understanding, will remain confidential, but that is again, I think we're in a better place than we are currently.
And there have been a lot of concerns expressed about lack of transparency about the process for complainants. In other words, it's hard for them to know what's happened with the complaint, what's being done with the complaint, what stages the complaint is at. And I think this contributes to a lack of confidence in the process as a whole. So again, in your view, will C-9 help make the procedures more transparent to the complainants?
I think the short answer to that is yes, particularly because there is a clear set of stages to the process, and the complainant will know at every stage where the process is, and will receive more timely answers because of that. So there's a first vetting that takes place in order to make sure that frivolous or abusive complaints are not allowed into the system. Then there's an initial examination of the complaint, and then it moves to a committee if it gets past that, and then there's the formal processes. So at each stage there will be a response to the complainant that would be available, and that in and of itself presents, I think, a much better set of transparent steps that allows for, I think, greater satisfaction on the part of complainants. Plus the fact that on minor, as you've pointed out, on more minor transgressions that I suppose are correctable in some sense, there isn't an all or nothing response anymore.
In terms of, I guess, complainants, one of the concerns that people have had is that once the complaint is launched, there's no more role for the complainant. So as a complaint makes its way through the system, there's no ability of the complainant to respond to any of the intermediate decisions or steps. Will there be any provision for this as a part of C9?
My understanding is that the complainant lodges a written complaint, but then the complainant, I believe, would have the opportunity to I guess restate that, at least in writing at the if there's a formal hearing on the case. But I can also get back to you more with a better answer, Mr. Garrison. And sorry, Patrick, I believe, can answer that.
Good.
Maybe help a little bit with that. So it's important to appreciate that the Canadian Judicial Council has a duty of procedural fairness toward the complainant, and the heart of that duty is precisely in order to communicate the outcome of proceedings to the complainant. The bill does not address that head on because the duty of procedural fairness is really variable. It will vary depending on the context, who the complainant is, what the circumstances of the complaint are. So it will be for the council to set out how it will deal with complaints in policies and procedures. It's best to leave that for policies and procedures because it may need to be amended from time to time. There is no sort of one-size-fits-all rule that could easily be put into the Act. So how to deal with complainants will be very much for the council to set out in its policies and procedures, and I'm sure the council will be pleased to speak to that when it appears before you.
I guess what I'm trying to get at here again is that some complainants have felt that they might have additional things to say or additional information to provide once they've seen the initial determination or consideration of the complaint, and that they feel currently there's no ability to do that. And I wonder whether that is covered by what you're talking about as the procedural fairness aspects.
Covered by that, and it would be addressed in the CJC's policies and procedures. Currently, a member of the CJC has the ability to go back to the complainant and get further clarification and get further information if they feel they need it once they've seen the judge's comments. But that's what the policy currently states under the current process, that what the policy will look like under Bill C9 once it becomes law will be for the council to determine. Presumably the council will have some consultations on what that policy will look like, but I can't speak for the council. The council will be able to speak to that when we appear before you.
Thank you, Mr. Xavier. Thank you, Mr. Garrison. Next, we'll go to our next round, starting with Mr. Caputo for 5 minutes.
Thank you, Mr. Chair, and thank you, Minister. It's always a pleasure to have you here before committee. I do have to ask a little bit of a selfish question following up from the last time you were here, and that was I did ask about Bill C-299, and that was the raising of sentences maximum to life imprisonment for sexual offenders. And I'm just wondering if you've had time to contemplate that and whether that's something that you might be prepared to support.
That's still under our contemplation.
I promise to keep asking you that every time you are here. Now, Minister, and I'm going to take a little bit of a circuitous route, but I promise, if I could have the Chair's indulgence, I promise to bring this back to the bill. But I'm going to give you a factual scenario that came up in case law in the last, it was in 2021. And I want to get your comment on it, and then I'm going to bring it back to this bill. This is a case that troubled me, and I know you can't comment on specific cases. But, Minister, what I'm asking you to do is comment on the legislative framework that permitted this decision. And that is a case called PRJ from the Supreme Court in my home province of British Columbia. And this was a case in which a mother offended against her daughter sexually. That daughter was 7 or 8 years old. 2 charges, an invitation to sexual touching and sexual interference. This case went to trial, meaning that 7 or 8-year-old had to testify. And the mother was ultimately convicted. The sentence was a 23-month conditional sentence order after trial with 12 months of house arrest for a sexual offense against one's child. Minister, do you have any comment on the legislative framework that permitted this?
Well, this is a horrific set of facts, as you have described them. There's absolutely no question about that, and I think we all share the horror of this kind of crime. There are a number of different procedures and provisions in place. I now, for example, have visited a number of child advocacy centres and funded a number of child advocacy centres across Canada so that the children and the families who go through this will be better supported as they go through this. As to the sentence, if that's what you're referring to, we best in the common law system leave that up to the judge with the sentencing guidelines and rules of thumb, and seeing the people before them, which is I think the great advantage of our criminal justice system based on common law traditions. So I won't comment on the actual sentence itself, but we are trying to build supports into the system so that people who are victims of these horrific acts are better supported as they go through the process, and we'll continue to look for ways to improve that.
Well,
Chair, I'm really concerned. This is the second time now I'm noticing from the members of the Conservative Party who are not asking the minister a question directly on Bill C-9, which deals with judicial misconduct, and continue to bring up very specific cases and asking the minister to opine on them. That has no relation whatsoever on bills, the matters that's covered in the Bill C-9. I let Mr. Brock go. I was trying to give him a little bit of latitude to see if he can bring it back to the bill, which he failed to do so. Mr. Caputo promised that he will do so in this instance, and he has not done so. I really urge, through you, Speaker, that members opposite really focus on the bill. We've got an opportunity here with the minister present to give us responses on this particular bill, and I think it's highly unfair that we are asking questions that are outside the purview of the work that we're doing right now. Thank you.
Mr. Chair, may I respond, please?
Yes.
Yes, thank you. I actually said I didn't ask the minister to comment on a specific case. I asked him to comment on the legislative framework, but we won't split hairs about that.
Which was not related to Bill C-9.
I did not interrupt you, Mr. Naqvi. I would appreciate the same courtesy. Thank you. Secondly, I said my follow-up question, which I'm happy to disclose right now, relates to Bill C-9, and it relates to that factual matrix. If I'm given the opportunity to do so with the full time that I have, I'm happy to ask that question.
So thank you, Mr. Caputo, and thank you, Mr. Naqvi. I will remind all members to keep it in line with the study, which is Bill C-9. So I give a lot of latitude to that. You had promised in the outset of your questioning that you were going to bring it back to C-9. So I ask that you bring it back to C-9. This is an important and very timely meeting, so we should keep it focused to that. And I'll resume your time.
Thank you. May I ask, Mr. Chair, how much time I have left?
You have
please?
a minute and a half left.
Thank you. So this is a horrific set of facts, a highly repugnant outcome, in my view, and I know you can't comment on that. But victims are often, particularly victims of sexual offenses, are often placed in a psychological prison, a psychological life sentence. And that's something that I came to learn in my work. I was trained in that. Now, we talk about training, we talk about Bill C-9, and we talk about doing the right thing. Minister, where should we be going when it comes to training of judges? And we are talking about that here with Bill C-9, when it comes to informing them of what victims go through in these circumstances.
Thank you. And I was waiting for the very, very good follow-up that came, so thank you. We've begun to take that into account with Bill C-3, which was the old bill originally proposed, private member's bill proposed by Rona Ambrose, which we took on and I think we improved, in which we can now require newly appointed judges as part of their application to agree to go through precisely this kind of training, largely as a result of another case in the C-9 file with former Justice Camp. And so we increase from the get-go the sensitivities, the abilities to understand what victims have gone through on the part of judges. And Chief Justices have told me that Bill C-3 and the work that the National Judicial Institute has done now in developing these kinds of courses will give them leverage over existing judges, because we can't, because of the principle of judicial independence, we can't force existing judges to go through training. But now Chief Justices are saying, because you've done this with the incoming group of judges as a matter of requirement, I can now exert more moral authority on the part of sitting judges to go through these kinds of courses. So I share Mr. Caputo, your concerns. I want to do anything we can to better train judges for precisely these kinds of cases, for precisely the kinds of facts that you have brought forward, and I continue to be open to good ideas.
Thank you. Thank you, Mr. Caputo. Over to you, Mr. Naqvi, for 5 minutes.
Thank you very much, Mr. Chair, and welcome, Attorney. It's always good to see you back here. Let's start with the existing process that's available to Canadians when it comes to judicial review and misconducts. What are some of the challenges that exist in the current system? And if you can then maybe in your second part answer how this bill tries to, in your view, addresses those in a meaningful way so that Canadians feel that they have a more effective recourse available if they face judicial misconduct.
Thank you, Mr. Naqvi, for the question. It's important. And I'll use the Giroir case as an example because it's fresh in many people's minds. So there is a process, again, that involves a petition on the part of a letter or a complaint on the part of a citizen. It goes to the executive director of the Canadian Judicial Council and then is screened by a member and goes to a review panel. And then from a review panel, it can go to an inquiry committee and then this nebulous council of the whole. At every point in the Giroir case, after every decision, there was a lateral move to seek judicial review at the federal court. And then it would come back to the process, go to the next stage, and person lost. And then it would go again across the federal court, the next stage, person lost. All the way up to eventually a leave to appeal to the Supreme Court, which was rejected, thankfully, and only then did the process end. So all of these lateral proceedings, because it wasn't clear that the review mechanism didn't prohibit these kinds of processes seeking judicial review. What we've done in the new process is established a line, so you're effectively appealing the substance of a decision with appropriate safeguards, with appropriate chance to make your case on procedural and substantive grounds, but not allowing constant judicial review to the federal court. Eventually to the Supreme Court by appeal if it is merited, and so there's an overarching guarantee of safety, if you will, for all participants by the presence of the Supreme Court at the end of the day.
So my supplementary to that would be, that you and the Department of Justice is comfortable from the perspective of natural justice and procedural fairness that this new mechanism still protects those important rights of participants versus in the current system where they could go and engage in those lateral steps.
Yes, absolutely right. And not only our department, but also the judges themselves who worked very hard on this bill. One thing I have to point out that particularly in both the Girouard and Camp situations, some of the people who were the most outraged were judges because they feel the reputational hit that these kinds of cases take, not only as individual judges, but also as part of the judiciary as a whole. And so they wanted reform. Believe me, the Chief Justice is watching what's happening and is constantly, in his formal way, telling me he would like to see C9 passed. And it's for precisely that reason, is that the reputation of the judiciary is very much at stake. They participated in these decisions. They made sure there was procedural fairness, but they wanted more efficiency. And that's true for both Chief Justices across Canada and the CJC, but also the Superior Court Judges Association. They want a better process to police their ranks, if you will, because they realize it's important for the reputation of the judiciary as a whole.
So one of the concerns that I've heard from individuals, and I'm sure I've heard the same, that the system seems, too complex, the way it exists right now. Cost is an issue, inefficient, and especially if you're a lay person, an ordinary citizen trying to take a judge, they feel that it's stacked against them to begin with. How would you assure Canadians that this new process that's being proposed in C9 actually is a fair system, less costly and more efficient?
Well, definitely less costly and more efficient because the lines are better delineated, and it's vertical now. You're basically moving up the system with your appeals, and you can't keep going sideways all the time, and that reduces costs and that increases transparency. It's also true that because of the formal role for laypersons within the system, there is I think, a better sense of legitimacy from the perspective of a layperson who might be a complainant, to know that there are going to be other laypersons within the system who are also going to have a look at what's happening. It's not just judges judging themselves, but also laypersons and lawyers. And that will ensure also diversity within the system, which is also critically important for the legitimacy of the system.
Thank you. Thank you, Mr. Naqvi. Next, we'll go to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur.
Thank you, Chair. Minister, I'd like to raise an issue that hasn't been raised to date. And it deals with the various possibilities of sanctions and consequences to the misconduct on the part of a judge. Have any economic sanctions been considered? Now, obviously, there's the issue of a salary that could be considered. Let's go back to the Girouard case, for example. Has anyone looked at the salary that is paid out during all these hearings? There's also the issue of pensions being received afterwards. Is there any way of tackling that based on the decision that is reached? And what I'm specifically interested in is the issue of costs. Now, I realize there's a limit being set on lawyers' fees, but I'm wondering if, let's say, the judge is found guilty of the misconduct. Let's say there's no reason to sanction, but if there is a serious mistake that has been committed, do you think that perhaps the CJC would have the possibility, not necessarily the obligation, but possibility of telling the judge to reimburse all or at least some of the fees or costs that were handled by the state? Thank you, Mr. Fortin, for your question. That is a possibility, but I'll give the floor to Patrick in a moment. First, however, I'd say that I think it would be possible, but what I would say is this. as I said, we have dealt with the pension side of this. So an individual will lose their right, actually, to that pension. It will be suspended. Now, in terms of the salary, I think it's frozen, but I'm not sure. I'll give the floor to Mr. Xavier to answer the question. I believe it's possible for the CJC to impose some financial sanctions, but I'm not sure. And I'm talking about the fees as well, says Mr. Fortin. Well, in terms of the fees,
So,
so there's a Bourbonnais ruling that we could talk about later, but under that ruling, the judge has a right to their fees being covered. So it's not clear whether or not we would have the possibility of asking the judge or telling the judge to reimburse those fees.
Thank you, Monsieur Fortin. Next, last, we have Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I'm going to resist the temptation that other members have indulged in to talk to the minister about a wide number of other things. I want to stick to confidence in the judicial system and the contribution of C9. But I can't resist saying that I know the minister shares my concern with systemic racism and the impact on Indigenous and Black Canadians in particular of systemic racism in our justice system. And with C5 apparently on the order paper at third reading in the Senate right now, I'd love to talk about that. But what I want to talk about is, do you think that C9 will make a significant contribution to the problem of systemic racism within the Canadian justice system as a whole?
Thanks, Mr. Garrison, for the question. Indeed, we're hoping that today is a historic day because we're hoping the Senate does get to a vote on C5 later this evening. I think it will have a positive impact. The visible presence of laypersons within the system, as well as leads to potentially greater diversity, as well as increasing the diversity within the judiciary, and in particular, the Canadian Judicial Council. We appointed recently the first Indigenous Chief Justice in Canada, in addition to the first Canadian member of the first Indigenous member of the Supreme Court, but the first Indigenous member from the Northwest Territories, the first Chief Justice. So she will sit as part of the Canadian Judicial Council, part of the CJC, which is critically important, and we hope that there will be others representing that kind of the face of Canada, if you will, the diversity of Canada. All of that helps in its own way fighting over-representation and certainly helps increase the legitimacy of the Canadian judicial system.
Thank you, Mr. Minister, and I do acknowledge that the appointment process has resulted in an increasingly diverse Canadian judiciary, but it's a slow process that takes time to make sure the judiciary actually represents Canadians as a whole. So once again, I thank you for being here today, and I have no further questions.
Thank you, Mr. Garrison, and thank you, Minister Lametti. We thank you for your presence here today on this very important piece of legislation, and we will now let you go, and we'll suspend for a few minutes.
Merci à vous tous et toutes.
Thank you to you all.
So for the sake of time, we're going to resume. And we will begin by allowing Mr. Xavier to say a few words for about 5 minutes to tell us about the steps on this bill, and then we'll resume questions. Over to you, Mr. Xavier.
Oh, okay. So I'm ready to start?
I can do it.
Okay, all right.
Good afternoon, Chair, members. I thought it might be helpful if Patrick, who is our expert on this particular file, would provide you with the state of the legislation right now and how it works, and a little overview of what we're proposing in case that might be helpful. We don't have opening statements, but I thought we could start with that, if that would be okay. Great.
Mr. Chair, I've become aware that you have a sign that indicates when someone's out of time. So I should have mentioned at the beginning that I'm mostly blind. I can't see that far. So my colleague will let me know if ever that becomes an issue.
My apologies.
Yeah. No. I should have mentioned. So I just thought I would provide a very brief overview for the committee of some of the changes in Bill C9 that are really the most salient and that will really help improve the effectiveness and the fairness and the transparency of the process. So it's important to appreciate that under the current process, Most of the process really takes place with a single member of the Canadian Judicial Council analyzing the complaint and then determining what to do about the misconduct in question. And that member of the council doesn't really have the ability to impose any kind of sanction. They can issue an expression of concern about the judge's conduct, but that's about all that they can do for misconduct that is not serious enough to warrant removal, which is the majority of misconduct that comes to the attention of the council. There is currently a body called the review panel, which performs a kind of gatekeeping function. So if the single member of the council who has the complaint thinks that it might be serious enough to warrant removal, they send it over to the review panel. That review panel is currently the only stage of the process where there is a layperson, which in this context simply means someone who has never been a lawyer and therefore also never a judge. That panel has only one task, which is to decide whether a public hearing should be held by an inquiry committee on whether the judge should be removed. If the review panel says yes, then that's when we're into the public hearings phase that I'm sure most committee members will be more familiar with. That public hearing phase takes place with the only members of the inquiry committee are judges and lawyers designated by the Minister of Justice. They hold public hearings. They issue a report to the Council of the Whole, which is as many CJC members as are not conflicted out, as have not taken part in the prior stages of the process. They look at the report and then they issue the final report to the Minister of Justice. And that, unfortunately, is when the opportunity for judicial review arises. So then the judge at that point can take the report to federal court if they disagree with it, then from there to the Federal Court of Appeal, from there to the Supreme Court of Canada, and that aspect of the process alone, that judicial review part, can take a good 2 years. So the new process makes several improvements to this to this current process. And the first improvement comes at the very start. Instead of a single member of council reviewing the complaint, if the complaint raises concerns about a judge's conduct, it will automatically be reviewed by a review panel, which includes a lay representative. So it will have 3 people on it, a member of the council, a judge who is not a member of the council, and a lay representative. And this review panel will actually have the ability to impose sanctions for misconduct short of removal, and those sanctions will not require the judge's consent. And there you'll find them in I believe it's Section 102 of Clause 12. And they include things like having the judge pursue a course of continuing education. So there was a question earlier about how this bill might help address systemic racism in the justice system. That's probably a key provision in that regard for C9. It's a way of having a judge who has misstepped in a way that suggests that they may be acting or they may be harboring certain stereotypes to pursue a course of continuing education to address that. From the review panel stage, then the complaint. Then the process becomes de facto public, and it goes toward it can go toward a hearing panel, which also includes a lay representative, and then that hearing panel issues a report which will contain a decision on whether the judge should be removed or not, and then that is when the appeal stage begins. So instead of waiting for the report to the minister and then having judicial review, the appeal stage immediately follows the full hearing panel. There is one appeal stage at the appeal panel, and then the possibility of leave to appeal to the Supreme Court of Canada, and that's all. That's where court review ends. Okay, thank you. And then from there, the report goes to once the appeal stage is complete, the report goes to the Minister of Justice, and that's really pretty much the end of the process. And so I'll leave it at that and let the committee ask questions. I don't want to take up too much time. Those are the principal improvements that Bill C9 seeks to make to the process.
Thank you, Mr. Xavier. I just want to tell you that was one of the best Coles Notes version of a bill I've seen, where everyone, I think every member of here understood how the process works. So thank you. It was very helpful. I'll begin by Mr. Moore for 6 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for being here today to discuss this bill. It's a bill that we support. The current process versus we've discussed already the limitations of the current process and how it's restrictive. The new process allows for sanctions short of removal. And I want to get your thoughts on the analysis of A, what you contemplate those sanctions looking like, or B, without revisiting, is there judges under the current system that have been dismissed where a sanction would have been more appropriate? Or is there going to be judges in the future that maybe, I think if you're in a position of a judge, obviously any kind of sanction is huge, to have that on your record or have a sanction against you. So is the sanction maybe an easy way out to deal with the case? Say, well, we're not going to remove this judge, but let's have them do some kind of training. The sanction obviously is a severe issue in and of itself to a sitting judge. So how do you ensure that we get that balance right between those that should be removed and those that should be sanctioned? And do you think that there's anything that needs to be tightened up to avoid misuse of the sanction?
Do you want me to take that? Yeah. So no, that's an excellent question, and it's a difficult balance to strike. The bill tries to strike that balance by focusing on sanctions that seem appropriate, that seem compatible with the judge resuming their full duties with the confidence of the public. So you'll notice that some sanctions that you might find in other workplaces, like suspension from duties for a time or suspension without pay, they're not really included. There's some question whether some of them might be fully compatible with judicial independence, but also it's sort of, if you include those kinds of sanctions, you sort of implicitly raise, you might sort of be implicitly raising the bar for removal. If a judge has done something so serious that you need to dock their pay, we're probably in the realm of something serious enough that removal is warranted. So as to where to draw the line so that you don't want to either overshoot the mark or undershoot the mark, the Supreme Court of Canada has set out in its decisions two main decisions on judicial conduct, which are referenced in some of your materials, Terrien and Moreau-Berube, that the bar for judicial conduct is very high. Judges really are expected to be a cut above in terms of how they conduct themselves. So with that in mind, the list of sanctions seems like a list of sanctions that is appropriate so that allows a judge to resume their duties with the confidence of the public. It's in line with the sanctions that you will find in other regimes, including in the provinces, as well as in countries whose legal systems and judiciaries are very similar to ours, like the UK, New Zealand, the US federal courts, and Australia.
Thank you for that. The minister mentioned the international experience. Do you want to discuss a bit what you, when looking at our process that has existed for some time, we're looking for a new way forward. What did you benchmark and what did you see as the international gold standard? And is there any way that you would point out as key differences for the Canadian context?
Yeah, so this bill, what's proposed in C9 actually compares very favorably with what's available abroad in countries very similar to ours. I can't say that there is a country out there with whose judiciary functions along the same lines as ours, whose process is better. The two aspects of, if you were to map out all of these processes, whether it's England and Wales or New Zealand or the U.S. federal courts, they broadly have the shape of a kind of capital letter Y. So the complaints come in, they get investigated in the same way initially, and then they go one of two ways. One way, if they're not serious enough to warrant removal. If they're serious enough to warrant removal, you have a more serious set of investigations that ultimately gets you to a public hearing and then removal by the executive and or legislative branches. So they do. This does follow that same pattern, but Bill C9 involves laypersons in the process at the very outset in terms of review of complaints, and that is not something that you find anywhere else. Laypersons are involved in England and Wales and in New Zealand, but only at the hearing stage when when it comes time to determine whether the judge should be removed. And the list of sanctions is very, very limited. Really, it's removal or it's a reprimand or expression of concern in these other countries. The ability to, for example, require a judge to pursue continuing education or counseling, that's not really there. So in those two respects, C9 actually really improves on what's out there internationally.
Thank you. Okay, thank you.
Thank you, Mr. Moore. We'll next go to Mr. Naqvi for 6 minutes.
Thank you very much, Chair, and thank you for the officials for being here. I want to pick up on the conversation I was having with the minister in relation to the current system and his concern about these lateral steps that people can take throughout the system in terms of judicial reviews, and how did we account for procedural fairness and natural justice as it relates to the new process. So if you can walk us through the analysis that you may have done in ensuring that we will not, if this bill is passed, that we will not run into an issue around breach of procedural fairness or natural justice.
Sure. So toward the judge, toward the complainant, toward both? Yeah.
Yes.
So as I
you.
said earlier in response to a question when the minister was here, the duty of procedural fairness that the council has toward the complainant is something that we're leaving, that this bill leaves for the council to do via policies and procedures, because the universe of possible complainants is extremely large. So, when the camp matter broke, there were hundreds of complaints, and all of those people who had read about it in the newspaper were complainants. In a case like that, where the victim of the judge's misconduct also complains, that victim is in a very different position, and the council might, should really treat that victim, that victim of the misconduct differently than the average person who has read about it in the newspaper. And it's difficult to come up with a one-size-fits-all rule that can fit in an act. Policies amendable from time to time are probably the better way to go, and so that's why this act leaves that up to the council. In terms of the procedural safeguards available for judges, the judge has paid counsel. We sort of covered that earlier. That's a very important procedural safeguard. The judge has the right to a hearing at which they can test and adduce evidence before they can be removed. That's the basic minimum that the Supreme Court has said is necessary in order to satisfy judicial independence requirements. The judge has a full right of appeal. So we've created a right of appeal that is not restricted. It's not an appeal on a question of law alone. It's a plenary right of appeal to an appeal panel that has all the powers of a provincial court of appeal. And then there's the right of appeal with leave to the Supreme Court of Canada, as you might have from any provincial court of appeal. And again, that right of appeal is plenary. There are no limits on it. So those are probably the most important procedural safeguards that help ensure that the process is procedurally fair. The only other one I could mention is the reduced hearing panel.
Yes,
so review panels will operate by written submissions only, and as that will be fair for judges in the vast majority of cases. But there may be the odd case where the circumstances might give the judge a right to a hearing, in which case they can basically ask for a reduced hearing panel. And so the reduced hearing panel will hear the complaint de novo. So it's not whatever the review panel did is not going to have an influence on the reduced hearing panel, and the reduced hearing panel can come to its own conclusion on that complaint. And the decision of that reduced hearing panel will be appealable to an appeal panel. There's a plenary right of appeal. So I think those are probably the most salient procedural fairness safeguards.
Thank you. Sincerely appreciate that for the thorough response. I'm assuming that the rules of procedure or procedures as it relates to this entire new mechanism will be developed by CJC.
Yeah.
Are there in this bill some clear markers that have been outlined that CJC shall follow as they're developing their rules of procedures?
I mean, there's obviously the rules of procedures will have to be consistent with anything that's in the bill, but there's no particular there's no empowering provision that specifically targets the rules. Every administrative bodies always have the ability to set rules that govern their own procedures, and that implied power it's pursuant to that implied power that the CJC will develop rules of procedure for the various stages of the process.
Just quickly, 1 minute. The process to appoint the layperson in this process as well, that process will be developed by the Canadian Judicial Council as well?
Yeah, the criteria will be set by the council, and the council will determine how the laypersons are selected and so on, yeah.
And in terms of term limits or the duration of that layperson to serve?
The term limit is 4 years, and I believe that's in the Act in Section 85, maybe in the 80s, 81 to 85, I believe, is rosters. So somewhere in there is the limit of 4 years for both laypersons on the lay roster and for judges who are not council members on the judges roster.
Great. Sorry, you want to add at any point?
Ms. Althmer has just reminded me, I mean, there is also the exhortation that the roster will have to reflect the diversity of Canadians. So that's I believe it's 85.5. So the council will be required to keep that in mind whenever it develops the roster.
Great. Thank you very much. Thanks, Chair.
Thank you, Mr. Naqvi. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you, Chair. And thank you for being with us, Ms. Decker, Mr. Xavier, and Ms. Ottmer. Earlier, I raised with the Minister the possibility of mediation, and if there was a point in time where it might be appropriate. And I'd like to hear what you have to say about this. Do you think that at some point in time during the process, once a complaint has been laid against a judge, but before you get to the sanctions, is there a point in time during the stages that one goes through? And do you think it would be appropriate to provide for time or space for a discussion with the judge in question? And perhaps there could be someone from the judiciary, someone from the department who would be involved in that discussion in order to deal with the issue that was raised through the complaint. Now, I think it might be difficult to convince a judge to accept a sanction, but what about other types of consequences? You know, the fact that the fees are covered affects trust on the part of the public because hundreds of millions of dollars are spent to defend an individual who has been accused of different kinds of behavior. And often this behavior is something that is shocking to the public. So do you think there could be a stage where one sits down and looks at possible sanctions in order to find a way to convince the judge to accept that they renounce certain privileges or renounce certain challenges to the complaint? Do you think that there would be a process whereby that kind of conversation could take place? Well, to my knowledge, that would involve the first stage. There's a member of the council who takes responsibility for dealing with this complaint, and mediation is part of this. And it will probably be part of what the review panel also will want to do. I think that the council is in a very good position, actually, to talk about what the panel will do exactly. So this will be part of the rules that I was referring to earlier, the procedural rules that will be drawn up. Because once there are public hearings, then the process becomes a little more adversarial. It's like a court kind of situation. And at that point in time, it becomes a little more difficult to have that kind of process. Not only because it's adversarial, but also because we're talking about more serious misconduct. And it might be serious enough to warrant removal, for example. So once you get to that stage, then mediation is not as straightforward. But mediation could certainly be something to consider earlier on in the process. Correct me if I'm wrong, but there is no possibility at this point in time for the judge to pay for reimbursement of lawyers' fees. Am I correct? There was the Bourbonnais ruling, I think in 2006. You have it in your material, actually, your documents. There was a federal court ruling in 2006, Judge Nadon, and they found that the judge has a right to a lawyer paid for by the estate. Now, reimbursing, any sort of reimbursement at the end is not necessarily something that would be allowed, but it's not clear. Well, that's what I understood from reading it as well. However, because it's not clear, would C9 not have been an opportunity actually to clarify that and to include this? Not necessarily for this to happen automatically, but to make it possible that the council, to make it possible for the council to request reimbursement on the part of the judge. Because when there's a mediation process, the judge shouldn't have the impression that it's just an open bar. You know, the judge may know from the very beginning that they can drag this out and his or her fees aren't going to cost him anything. So perhaps we're missing an opportunity here to have some kind of leverage and to actually give the judge the will to actually resolve this issue. I realize you're saying it's not clear. Well, the bill as drafted reflects the expectations that are consistent with the Bourbonnais case. Now, there will be a more efficient process, and so these costs won't be as high under Bill C9. Thank you. Thank you, Mr. Xavier.
Go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I do want to assure you and the translators that it's my hope to always be present in person for the rest of the session. I want to thank the officials for sticking around with us for the second round. And I thought the opening statement, if we call it that, was very useful. I want to follow up on that by asking questions just very specifically. At what stages will the complainants be notified? And what's the extent of notification through this process? And secondly, is there any opportunity for them to provide additional evidence or arguments having seen an initial determination, say, at the review process?
Did you want to take this or should I?
No, you can take it.
So I thank you, Mr. Garrison. So I mean, as I said earlier, I think unfortunately those are difficult questions to answer just based on C9 alone, because that will be part of what the CJC will have to provide for in its policies outlining how it will deal with complainants under C9. So currently, when the CJC has carriage of a complaint and and asks the judge for submissions on the complaint and receives submissions that indicate that maybe some clarification of the complaint is required, my understanding is that the CJC does absolutely go back to the complainant and ask for clarification, ask for more information. If the CJC has a sense that more information should be available for whatever reason, it will go back to the complainant and ask for more information. But that is all of that is very much going to be regulated by that policy and procedure on how the CJC will discharge its duty of procedural fairness toward the complainant. Yeah, go ahead, please.
I would just only add that I wasn't involved in all of the consultations with the CJC as Patrick was, but in a couple of them, I can tell you that the complainants, rights to procedural fairness and being involved in the process was top of mind. So what they do come up with, we'll see in their guidelines, but I know that they're certainly alive to this issue.
They definitely are, yeah.
So apart from the legal obligation of procedural fairness, is there anything in C9 that specifies that information will be provided to the complainants at each stage of the process? I know you keep saying this can be the policies, but I'd like to know if C9 creates an obligation to have policies that deliver adequate information on the process to the complainants.
So the obligation flows from procedural fairness. The federal court has found that there is a procedural fairness obligation to notify the complainant adequately of the outcome of the process. So that's a legal obligation that the CJC has, that the federal court has found the CJC has. So it's not expressly stated in C9, but it's not really necessary to state it. It is a legal obligation the CJC has, and that they're very keenly aware of. That's why the bill doesn't need to go into it in any detail. It's there, and the CJC is well aware of it.
So just to be clear, the phrasing you used is to notify them of the outcome of the process. But what I'm asking is whether there's no. Sorry?
To notify them in a meaningful way of the outcome of the process. I mean, they have to have, it's not a matter of, exactly how extensive the reasons have to be will depend on the complaint, but they do have to be notified in a clear way how their complaint was dealt with.
But only at the end?
The CJC will be in a better position to speak to whether that's only at the end or whether there are intermediate stages. I mean, currently, I can say that for complaints that are entirely public, because some complaints are entirely public from the beginning, the CJC issues press releases at every stage of the process saying, the complaint is now at this stage, the complaint is now at that stage. So whether they follow the same practice with complainants, I can't say, because we don't manage the process. The CJC manages the process at arm's length from the department, but it may well be at every stage of the process. They'll be in a better position to let you know how it works behind the scenes.
Okay, thank you. You may not have an answer to this question, but I'd like to ask about the level of what we call frivolous or vexatious complaints, and have we seen a change in the number of complaints that would be more about not liking the outcome of cases rather than the actual behavior of judges? So has there been a trend toward additional or toward fewer of frivolous and vexatious complaints?
I mean, that again is a question that the council would be better placed to answer. I can say that what we see are the judicial review applications. A complainant can always judicially review a council decision that they're not happy with in federal court, and that is not going to change following Bill C9. Bill C9 is only doing away with judicial review by judges. Complainants can still judicially review the council, and in these judicial review applications, there is still, the ones that go to court, there is still a fair number where, the question is this judicial decision-making or is this really judicial conduct? That's a line that it seems every judicial council has to walk. It's a difficult line to walk. And there a lot of the ones that go to court still turn on that question. Whether it's a trend or not, I'm afraid I can't say.
Thank you very much. I'll follow up later with those. And that will conclude my questions. Thank you, Mr. Chair.
Thank you, Mr. Garrison. Next, we'll go to a 5-minute round, beginning with Mr. Caputo.
Yes, thank you, Mr. Chair. And I will be splitting my time with Mr. Van Popta, so I'll endeavor to be a couple of minutes here. Now, thank you to the panel. One question I have is this: when lawyers are subject to a citation that's been founded to be appropriate, as in the process is somebody makes a report to the governing law society or organization. If it's frivolous or vexatious, it's dismissed, just like in the legislation, right? There's that gatekeeper function. But then it becomes public for everybody. I'm trying to recall, my understanding is that does C9 make that same complaint public?
So the complaint at what, does it make it public at what stage?
At the point of investigation.
So whether the complaint becomes public as soon as you get to a hearing panel, because once you get to hearings, Section 2B of the Charter sort of requires openness, and at that point, it becomes default public. Whether it's public from the beginning depends on the nature of the complaint and the complainant and so on. So some complaints are kept confidential because the complainant wants them kept confidential. Other complaints are public from the get-go because the complainant wants them to be public or because the misconduct in question has been public from the beginning. So it really depends on the complaint. And that's something that, again, the bill leaves to CJC policies because how to navigate confidentiality in those early stages of the process is really tricky. It really depends on context.
Okay, thank you. I may have misheard the minister. I thought that it would remain confidential. So
it's not automatic, no. Confidentiality is not automatic. It really depends on the complaint.
Oh, okay. Thank you. And just generally a comment. I think that moving towards a system where, like lawyers, judges can have all sorts of sanctions, because I think that anybody who's practiced law, like most of the people here, have seen really 1% of judges have caused occasionally issues that may be disrespectful, things like that. So I do look forward to the fact that we are addressing this as a profession. And I'll give my time now to Mr. Van Popta here. Thank you.
Thank you. Thank you, Chair. Thank you to the witnesses. So we're here talking about reform to the judicial misconduct complaints process, which is pretty dry stuff. But on the other hand, we're talking about the administration of criminal justice, which of course is very, very important to the way Canada operates, and it's very important to the public. So my question is about the perception that the public has about how the judicial system works. Is there a mandatory reporting that the Canadian Judicial Council has to give annually about how many complaints there are, and how many were frivolous and how many went into that direction in another direction? Because I think this would go to the confidence that the public would have in our judicial system to know that there is this level of transparency.
So currently there isn't. The council does issue an annual report where it provides that kind of information, but there is no current requirement. But Bill C9 is going to change that. So I believe it's Section 160 at the end of Clause 12. It imposes a requirement for an annual report where certain numbers are provided in terms of numbers of complaints and the breakdown of the complaints that the council dealt with every year.
So there's been no reporting up to this stage, but there will be reporting once.
No, there has been reporting every year. The council does it, but it's just not required.
Okay.
Now it will be required, and I believe Section 160 stipulates some things that have to be in the report. So, but those things are largely in the reports already. So it reflects established practice. It's just going to be a requirement.
Good. Could you give us just a sense of scale? Like how many complaints are there in any given year, and how many result in sanctions or removal? We all know about the Camp case, of course, was high profile. How many low profile cases do we see every year?
Yeah, my understanding is that there's around 600 or so complaints a year. It varies. It depends on the year. It varies quite a bit. There's some years it's closer to 700. Some years it's a little bit lower. It's probably, I would say over time it's probably trending a little bit upwards, but that's also because the federally appointed judiciary continues to grow. So we have more. It does, yeah. We have I think now, is it 1,200? Around 1,200? Around 1,200 federally appointed judges.
So 1,200 complaints, 1,200 files that are
No, not 1,200. 1,200 federally appointed judges. So more judges probably means that the number of complaints grows a little bit every year. But
fair enough. So
it's around the 600 mark or so every year. How many are frivolous? How many are vexatious? How many go forward? That information, unfortunately, we don't have. You'll have to inquire with the council.
That will be required in the new reporting?
Yeah, it will be part of what will come out in the reports every year going forward.
Thank you, Mr. Van Popta. Next, we'll go over to Madame Briard for 5 minutes.
Thank you, Mr. Chair. Bonjour à tous et...
Good afternoon to all of you, and thank you for coming before the committee. Earlier, we were told that C9 would improve effectiveness, efficiency, and reduce delays. However, there still will be a review panel, a hearing panel, and a full hearing panel, and ultimately, potentially, the Supreme Court of Canada. So can you please confirm that your goal will be reached? Yes, absolutely, that goal will be reached. It's true that there are several kinds of panels. However, the process is doing two things at the same time. So there's a process that will determine whether or not the judge is guilty of misconduct and has to be sanctioned or not for minor faults. There's another process to determine whether or not the judge should be removed from their office, and based on the Constitution. So that's why I said earlier that if you kind of try to do a diagram, it's kind of in the shape of a Y. So there's one of two directions it can go in. So the reason it feels a bit or sounds a bit complex is because there are these two processes. But yes, our goal will be reached. Thank you very much. Now, the very first condition for judges is that they can't be removed for an arbitrary reason. And this is under Section 11D of the Charter. And there's also another condition that has to be met, and that is public trust. What I'd like to know is how the changes under C9 are consistent with these sections in the Charter or protected by the Charter. Well, C9 is consistent, yes, absolutely. A judge has the right to a hearing where they can be heard and where they can be represented by a lawyer if they so wish. And evidence has to be produced and examined, and that's when you have the hearing panels that are designed specifically for that. And then the judge has a right to appeal, and there are no restrictions on that appeal. And the same applies to the Supreme Court. As I mentioned earlier, there was the Bourbonnais ruling that provides for the judge's fees being covered for the process. And under C9, C9 is consistent with this and consistent with Section 146, I believe. So C9 does ensure that all those rights are guaranteed under 11D. Thank you. Can you also speak to some of the consultations that led to the drafting of Bill C9? Yes, there were consultations at various levels. The department prepared a document for the purposes of consultation that was published on the website for the department. Then the public at large had an opportunity to give feedback on that document. And we also were able to look at the feedback provided by the public and look at the various comments that had been made. We also consulted the CJC, and we also consulted with the Superior Courts Judges Association. We further consulted with the Federation of Law Societies. There was also the Council of Canadian Law Deans that we consulted. And then the Canadian Bar Association. We also consulted with various lawyers who have represented judges in previous disciplinary reviews. We consulted lawyers who had been responsible for producing evidence and who had also been involved in the hearings. We also received submissions from the Quebec Bar Association and on the part of the Canadian Association for Legal Ethics. So this is an association that involves ethics and law professors, and we also consulted with the provinces and the territories. So it was a rather comprehensive consultation. And we heard and considered all the concerns that were raised by those who provide us with feedback. And many of these concerns dealt with the issue of the processes being too long and too costly. And that there wasn't an opportunity for members of the public to be able to participate at various stages in the process in order to determine whether the judge was guilty of misconduct or not. Well, thank you very much. You even answered the question that was coming.
Madam Briere. Now we'll go to Monsieur Fortin for 2.5 minutes.
Thank you very much, Chair. And good afternoon, or good afternoon again. Mr. Xavier, when you were listing the organizations, there were several of them, and you said that you also had received a submission from the Quebec Bar Association. Am I to understand that you hadn't actually consulted with them from the outset? There was the Federation of Law Societies, and we had asked the law societies to send our document on to all the bars in Canada. And we expected the submissions from the association to reflect those bars. But we did receive a separate submission from the Quebec Bar Association. I see. But you didn't make a specific request to the Quebec Bar. No, we went through the Federation because the Federation does consult with the various bars. I'm sorry, I don't have much time, but I did have another question for you. Bill C-9 is a new version, a new attempt at amending this process. There was S5 and S3 as well that were tabled previously, and they died on the order paper. Can you give me an idea of the main differences between S5, S3, and C9? It's the same bill. There really isn't much difference at all. Thank you. So, in that case, none of these bills considered the possibility, if I've understood you correctly, to require that the judge reimburse any costs or fees. No. No, these bills were all identical to C9. Because I understand that there's the Bourbonnais ruling, and I don't necessarily want to be repetitive. However, it seems to me that it would have been appropriate on more than one occasion to look at all the jurisprudence in order to see if there were a way to do this. I think it's an important point when it comes to public trust. So would it not have been appropriate to consider this as an option? Well, all applicable jurisprudence was considered, and we feel that Bill C-9 does reflect that jurisprudence. And that's really all I can say on that. I see. So you don't think there's any... Thank you. Thank you, Mr. Xavier.
Witnesses, I think Mr. Garrison's already conceded his time, so we'll conclude this. I want to thank Ms. Decker, Mr. Xavier, and Ms. Ottimer for coming today. And we will end this portion. I just have a couple things on committee business. Just want to let you know the deadline for submitting amendments to Bill C-9 is scheduled to be on Thursday, December 1st. So we have to establish a deadline to submit amendments. As per routine motions, there's like a 48-hour notice required to submit those amendments, if there are any. So I think if we have that deadline to be 6 p.m. on Monday, November 28th, that should be fair. And also for supplementary estimates, they've been tabled in the House as of today. And as per our calendar, we would be able to have the minister appear on the matter on December 1st. And I think I'll have the clerk coordinate with the minister and see if that's available. So just want to let you guys know on that. Barring any questions, I will, yes, Mr. Munson?
Yeah, we need to check the availability, so
Yeah, of
if
course.
you can give a flexibility on the date.
Sure. All right, I will adjourn and see you next week.